Okay. Okay. And all right, I see Phil is here. All right, so I apologize. I was running a little late right there. And I'll just check to see if everyone is here.
Do we have Bernie on? I see I know we've got Sean Mulholland.
Yeah, Bernie's here with me.
All right. Because I can't see you guys.
All right, so I'm here, Barry, Devin, Kathy, Casey. Okay, and I see Devin. Okay, good. All right, it looks like we are all here then, and the recording has begun. All right, this is Karen Leo Hill, going to call to order the meeting of the Fair and Impartial Policing Task Force, and I will turn it over to City Manager Mulholland to read the disclaimer.
This meeting is being conducted in accordance with the provisions of RSA 91A and Emergency Order 12 issued by the Governor of the State of New Hampshire. The meeting is being conducted virtually because of the COVID-19 pandemic. It is not practical for the task force to meet in person, run the risk of spreading the virus, or nor is it practical to allow the general public to meet with the task force for that same reason. So therefore, it's being conducted virtually. Folks can participate by logging into the Microsoft Teams link, or they can call in by phone. And when they're recognized by the chairperson, which is Councilor Hill, they will be allowed to speak at that particular time. Dial *6, and that will allow you to access the meeting by phone and speak at the meeting.
Thanks so much, Sean. And so let's go ahead and have the roll call so we can see who is here. Oh, and actually, okay. Barry Schuster.
Here.
Devin Wilkie.
Wilkie is here.
Casey Montaz.
Casey Montaz here.
Sue Prentice.
Here. Prentice here.
Yep. Kathy Beckett.
Here.
Diane Root. I don't think I see Diane.
Diane is having trouble I'm going to forward her the link. She's having trouble finding it.
Okay. Okay. So hopefully soon we will be joined by Diane. Karen is here. So we are all here with the exception of Diane.
Started. Oh yeah, it's all over.
I guess I'd like to just give her a minute to, let's give Diane a minute just to let her join in. So everyone sit tight for just a minute or two.
Monkey on your back.
All right, Sue, do you want to mute yourself? Oh. Sue?
Sorry, I had to step away quick.
No, that's all right, but you can mute yourself if you want next time.
Okay.
Yeah. We're just giving Diane Root a minute to connect because it sounds like she's just getting ready to, she's hopefully logging in. Kathy, any word from Diane?
It doesn't help that my computer is very slow.
Oh no, okay.
Hopefully soon.
Okay. Sean, would you be able to share the agenda for tonight?
I can.
Okay.
Let me just let this person in. You'll have to let other people coming in.
Okay. Yes. All right. Yes. Yay! And Diane is here. Oh, good. Perfect. Welcome, Diane. And you can just say present so that we all know you're here.
Present.
Okay. Good. All right. So now everyone is in attendance, which is great. And Sean has pulled up the agenda for tonight. And mea culpa, I have to email you all the minutes. So we're just gonna have a big batch of minutes for our last meeting. I think it will be our last meeting anyway, in 2 weeks. So our discussion items tonight is basically everything. But we've actually covered a lot of this ground at our last meeting. We did a lot of good work on provisions 1, 2, 3, 4, and 5. Definitions. Let's see, provision. I can't quite read that. What's the next one underneath definitions, Sean? Provision 6.
Yeah, provision 6, purpose statement, and then provision 9, implementation and enforcement.
Okay, so I think if it makes sense that Bernie, you had prepared some notes. So at our last meeting, one of the last things that we were discussing that we agreed really needed to get addressed was the question about provision 6, the notification provision, and whether and there was concern that was raised by Bernie, and then also shared by Paula Mayville, who was sitting in for the city manager, about whether employees of the city could be personally liable or could have some personal liability, criminal liability for breaking the law by if they had to do the notification that was required in provision 6. So that was kind of the biggest issue that was still outstanding at the end of our last meeting. So I guess I'm wondering, maybe I want to just ask the group, should we start with that issue, or should we address some of the other things first? What is the, I guess, what is the will of the task force for tonight? And I can't see anyone, so.
Can you hear me?
Yeah.
So isn't provision, I just want to, for clarification purposes, provision 6 now provision 8?
Yes, that's right.
Originally it was provision 6, but I thought at the last meeting, and what I've been looking at is that was moved and is now provision 8. So I just for clarity, because it's,
Former, I should have said former.
Yeah, it's okay. I wanted to make sure that, and then I mean, if that's, it seemed to me like at the last meeting that a number of these other areas have been reasonably settled, that maybe we should get to this question that came up at the end of last meeting about provision 8, and because I think that if anything's going to take time to discuss, at least in my opinion, it's going to be that tonight, and then we can. That's my opinion. Okay, I'll stop now.
Does anyone disagree with the idea of starting by digging into, provision 8, the former provision 6?
This is Kathy. I just want to be sure that we do talk about implementation and enforcement, that we make sure we have enough time for that.
Okay. All right. Anyone else have thoughts on this? Okay, I'm gonna suggest that we start with the notification, and then we move to enforcement and implementation, so that at least we cover these 2 areas tonight. Because I do believe we did have consensus on a lot of the other areas. So. So Bernie, you worked on this. Can you please share with the group where you have where you are at this time with regard to provision, the notification provision?
Yeah. Well, I think I'll save time by not going through the entire, whatever it was, 8 or 9 pages of of stuff that I produced. I think the summary is that I think if somebody were prosecuted for publicizing or notifying the of the presence of a highway checkpoint, I thought that the chances of actually being convicted were not very high. On the other hand, it's a gray area because I found, my reasoning was from by analogy with things like speed traps and sobriety checkpoints, which just really aren't quite the same, because the the purpose of those is to in essence deter violations, whereas the immigration checkpoints really don't have that same purpose. I have found nowhere else in the United States that has adopted a similar provision or that it has been litigated. I went through the applicable laws, and I think if I were defending somebody, I would have a pretty good chance of winning. On the other hand, it's still going to be the case that the city doesn't defend individuals for criminal violations. So you'd still be leaving city employees out on a limb a little bit. So that's not a very satisfactory answer, I know, but I think the chances of conviction are low, but it's still a gray area.
Thank you, Bernie. Okay, so our charge, the charge for the entire task force was to keep as much of the language from what was passed by the voters as possible, and addressing narrowly tailoring our work to address the areas of around enforcement and the areas that legal counsel had raised. So I just wanted to remind us all that that's what we're trying to do here. And so let's have some discussion. This is something that we've worked a lot on, actually, on this notification provision. Let's have some discussion among the task force about this.
This is Kathy. I have a statement or an opinion from Kira Kelly. I'm not sure. It's about 2.5 pages. Should I try to pick out the relevant points?
Is this something that has been shared with us?
No. Should I share it with you? I just got it today, when I got home recently. So should I email it to Sean Mulholland?
Yeah.
Or you can share your screen. Or you can send it to Sean, and Sean can share a screen.
That sounds like a good idea. Yeah, I don't think I'll try that.
Okay. Don't be afraid. I do it all the time.
Oh. Okay, I'll do that.
All right. So while Kathy is doing that, then let's see what are other people's thoughts on this so far here. Casey, are you raising your hand?
Yes. So I want to commend the research done by Bernie. It is amazing. I think I read through all of this, and I think at the end, I sort of came down to realize that on point number 6, when he talks about the New Hampshire statute 642(3), it specifically talks about a crime, and in this case, we are talking about U.S. immigration laws, which are considered violations, civil violations, not crimes. So in that place, does not apply. Also, ultimately, in the federal statute, it specifically talks about a specific person, knowledge of a specific person. So there is this idea of a specificity that we lack over here. So I think I wrote something where it says that at the checkpoint, they are not looking for person X, and a Lebanon official, we have personally known person X, and then call person X and say blah, blah, blah. It is completely different. They are not there looking for a specific person, otherwise they will have a warrant, which is completely different. And we have no knowledge that they are looking for any specific person. We just have knowledge that there is a traffic backup there on I-89. So in so many ways, I feel so much more comfortable about this. And I do agree with the ultimate recommendation that if we go forward with it, that we are not talking about any specific individuals. We don't have any knowledge of any specific suspects that are being sought out. The other thing that I wanted to point out is that the whole idea that they do this enforcement, these checkpoints, for the sole purpose of apprehending violators, Where did I see that somewhere? Because I know I made a note. You find it. In any event, it's crazy because on that action that they did on the 6th of September last year, they inconvenienced thousands of people, and they came up with four detentions at all. So if that's what they are doing, this is how they want to make arrests. It's a waste of time, money, and the inconvenience of a lot of people. So I don't think that their point is to arrest people. The point is to intimidate. Sorry, that's an opinion. I shut up now.
No, that's good. This is important. This is why we have to have this discussion. So, because this is going to be, one of the major points. I think this will be a serious issue for the city council. So we need to discuss this and make sure we are comfortable with our recommendation. Who else?
I guess a question for Bernie about why, if a city officer or city employee reports this, why wouldn't the city protect that person? Why would it be an individual defense and not a city defense?
You want Bernie to answer that? You want me to answer that?
I'm not sure that I can answer that without going back to sort of the basic law of municipal. The number one principle of municipal law in this state is you can't do anything unless the legislature says you can. If you look at the statutes that talk about things that a city or town can indemnify somebody for, that's located in somewhere right around 31105 and 31106 and 31104. And, it allows you to indemnify for negligence and torts, except for intentional torts. And it allows you to indemnify for federal civil rights violations. It does not allow you to indemnify for criminal violations. And I'm just not aware that any town or city actually does that, and I'm not sure that they would have the authority.
Well, it isn't the city employee simply following the mandate of a city ordinance, and you're indemnifying or defending them because they're following a city ordinance? Yeah, they're doing what the city has told them to do.
Yeah, I hear what you're saying. I don't have any precedent for defending an employee against a criminal charge, which is basically what it would be. If I were put in the position where I was the official of the city, specifically responsible for doing this posting online and so on and so forth, and I were in the position, having done the research I've done, I would probably not do so unless I first tried to get a court to tell me whether I should do it or not.
Casey?
Oh, you have to unmute, Casey.
Sorry, I have two buttons. I have to do it twice. I will say that I agree with what Barry says, because they will not be acting as individuals. They will be acting on behalf of the city, following through what ordinance have been voted on. But on the other hand, nor in the New Hampshire statute, nor in the federal regulations did I see that this action will carry the elements that will amount to a criminal violation. Therefore, if I see a prosecution based on this, I will think it's a malicious prosecution, because I don't really see that doing this meets the element that will amount to a criminal violation on the New Hampshire statute, nor under the federal statute. So I don't know.
Wait, so is this a criminal violation or a civil violation?
It's a violation under the criminal code. It would be if it went under state law, and also it's a criminal violation, at least hypothetically, if it could be brought as a criminal violation federally as well. It would be that statute that I mentioned in there about accessory after the fact.
Wait, Casey, unmute.
Here we go. So accessory after the fact, as you went through that, the elements for accessory after the fact are not there. It is not specific. It is not known. It is not, I mean, I will see that if the city of Lebanon received a warrant saying, I'm looking for Casey Montaz, and then an employee of the city of Lebanon with that information, with that warrant, which is based on a court order, not on looking for a possible civil violation, then calls Casey Montaz and say, Casey, get out. They are coming for you. That's completely different, according to what the statute said. It's not. So, I mean.
Well, I agree with you. I mean, that was my conclusion, is that the elements would not be met. But we're talking about two different things. You know, prosecutors often bring, I don't know about often, but sometimes bring prosecutions where they are not successful. And if they do, Barry's question was, why couldn't the city defend them? And I don't know. I don't have any. I didn't research that question, but I know of no municipality in the state that offers to defend its employees against criminal prosecutions.
Okay, is that Barry? Is that a question that we should get answered?
I guess we should. I agree with Casey that you know, the notion of a criminal prosecution because an employee is following a city ordinance, to me, puts the employee in a no-win situation. If they do what they're told, then the city says we're not responsible, and if they don't do what they're told, they can be fired. So, you know, I think that the city has an obligation to at least, even if it's not defending the person on the criminal side, if the person were ever charged on a criminal situation, before that ever went to court, get a statement or defend the ordinance. And if the ordinance is held up, then the prosecution goes away. But there should be some layer of insulation to protect employees who are doing what they're told to do.
What is this called when you ask a court to make to settle a matter? What is that called?
Declaratory judgment.
A declaratory judgment. Okay. All right. I see people with their hands raised. Sue, I saw Devin for sure, and Sue, did you have your hand raised?
I was just kind of waving around in irritation, but I'm okay. Go to Devin.
Okay, Devin, go right ahead. Okay.
I'm just.
So, while we're waiting for Sean Mulholland to receive Attorney Kelly's response,
I have it, by the way.
I want to bring out one point that was listed there, which is that while the risk of a conviction is almost non-existent from what it sounds like we're hearing, she recommended that the city may wish, quote unquote, to explore whether a criminal defense attorney in New Hampshire might sign an agreement with the city offering to provide pro bono representation in the unlikely event that the ordinance results in criminal prosecution. So given that we don't necessarily have any answer or precedent for judging whether this could result in a criminal prosecution, and two, whether the city is or is not able to defend the individual, might that be another alternative that we could factor into our recommendation, that the city could help to find potential pro bono representation in the unlikely event this happens.
Well, this is Bernie again. Can I just say one thing? Is that I think, again, my client is the city here, but just assuming that I were representing an individual who was ordered by this ordinance to do something which I didn't know whether it might result in criminal liability or not. And my advice might very well be, initiate some kind of action where a judge is going to tell you whether it's lawful to do that or not. And if the city decided that it had an interest in the outcome of that, it could pursue it. It wouldn't be defending somebody from a criminal charge, but it could be pursuing a declaratory judgment the same as the individual could. So that is one. I mean, I can't imagine, frankly, just going ahead and doing it without getting some further statement from a court, because it's just, there's no precedent on this.
So, Bernie, is it possible for us, would it be possible, for example, to seek a declaratory judgment on this provision of the ordinance, like right now?
No, because it's not enacted yet. And the court would say that it was a hypothetical question, and you have to have real people with real interests. It would be premature.
So what if we come up with some version that the city council enacts and then it goes into effect on January 1, could we seek a declaratory judgment on January 1?
The city could choose to do that, yes.
And that would be enough of a triggering. We don't have to actually have be imminently taking the action. As soon as it's enacted, then it goes out of hypothetical and becomes something that we could seek a declaratory judgment.
If you have somebody has a present duty to act under this ordinance, then yes, that's no longer hypothetical.
All right, well, that's something that we could think about, just so everyone keeps that in mind. We could potentially, come up with language that we think would be good, recommend it to the city council, but then at the same time, simultaneously recommend that immediately upon enactment or, whatever, that we immediately seek a declaratory judgment to settle this question. That's just, I'm going to put that out there because I have to say, I have a real problem putting our city employees at jeopardy of feeling that they have to choose between breaking the law, even if we think the risk of conviction is low, or losing their job. I just think I am just inherently uncomfortable with that. And I would not feel comfortable moving forward with it. Even if the risk is low, I'm not comfortable with this. I would be comfortable potentially, I'm thinking out loud here, because I want to see this stay in there. So I would potentially be comfortable if we had that kind of a scenario where we were to immediately seek declaratory judgment, so that then if the provision was found to be unlawful, we could strike it, and I'm sure we already have a severability clause or whatever in there, and so on. So I just want to put that out there as one possible scenario, because I think we probably all have some level of discomfort with asking city employees to be in this predicament.
Are we frozen?
Is who frozen? No?
I think I was frozen for a bunch of that.
Uh-oh.
Was it else? Was it just me?
It
was just me.
Oh, I think it was just you, Sue. I'm sorry. So you didn't hear me?
Okay. I only heard the very beginning part where you said you'd be very uncomfortable. You got to declaratory judgment, and then it was like, I couldn't see I could see you all.
I didn't really say anything more than that, so it's fine.
Okay.
All right, who's got their hand up now?
Actually, Diane had it up before me.
And then Barry. All right, and then Sue.
Okay, yeah, I just want to, I'm with Casey. Karen, I agree with that concern for our employees, just sort of the matching other side of that, I think, is just as I don't want to put our employees at risk, I'm also really offended by the idea, you know, Casey said if someone brought that suit, it feels like that would be a malicious effort. And it feels like kind of the kind of bullying that has gone on around this issue that I don't want to be intimidated by. So that's the tension, certainly, that I'm feeling. That I don't want to put our employees at risk. I also don't want to be bullied out of what is an important service to offer to our community. So that's all.
Yeah, no, that's a fair point. That's absolutely, I hear you. Barry.
I just wanted to emphasize something that Bernie said, that courts need a real dispute, and even if theoretically that could occur after January 1st, I would be hesitant to, you know, on our own go forward with a lawsuit to see if it's legal or not, because there may be some facts on how things occur and how they unfold that may be very relevant, and it's very hard for judges to make a decision on something like this without some basis of activity, some facts involved. But I think it's something to sort of keep on the front part of the shelf and be ready if necessary. And besides, as Casey and Diane said, the likelihood, the city is not going to bring the prosecution, and the city's not going to refer a prosecution to the county attorney, and the likelihood of some prosecution being referred to the state AG's office is unlikely. Would it be a federal prosecution? I suspect there would be a lot of discussion before that it ever came to that. They're not going to come swooping in and arrest somebody in Sean's office because they put something on the website. I think there would probably be a discussion, and we have plenty of time before we go to court on it. I think that the language serves a purpose, and we can certainly be prepared, but I wouldn't go racing out to court on it.
Would you race out to court? I mean, the problem is that if we do it, then someone, you know, you can't undo it. So we can't get a declaratory judgment after the fact. That's not helpful because someone could potentially be criminally prosecuted. And
no, you could have a simultaneous action on a civil side to have a court rule on the law based on the facts as they arose. And it wouldn't even be defending that person, it would be defending the ordinance. And again, from a practical standpoint, it would be very unlikely for the federal government to come swooping in and arrest somebody because they put something on the website. That would be the height of a malicious prosecution. And I don't see that happening. I think that there's enough awareness of what this is trying to do that there would be a communication such as take that off the website or we'll do something. Or if you do it again, we'll come after you. You know, I wouldn't want to cry wolf too quickly. That's all.
But hold on a second, though, because if we were to pursue a simultaneous declaratory judgment and we did not prevail, then that employee would be exposed for that criminal prosecution, wouldn't they?
It's possible. I suspect so.
Right. So that's my issue. If we wait until an action has already been taken to pursue a declaratory judgment, then if we're wrong, if we don't prevail, then we have left that person on the hook.
I don't know the answer to that. I don't know the answer. And I'm not sure if I necessarily agree with Bernie. I respect what he says about the city not having an ability to indemnify employees. I have not researched it, and I can't imagine that if there's a city employee doing something in the course of their employment that resulted in some prosecution, that the city wouldn't defend them. It just, an ambulance driver racing to a scene but forgot their driver's license, and they get arrested for not having a driver's license, but they're racing because that's part of their job. Would the city not protect them? I find those things hard to believe.
All right.
And Bernie, I trust you to figure the answer out.
Yeah. All right, Sue and yeah, Sue, go ahead.
So two things, but I think it all wraps into one. Can we consider, so I know we talked about this at the last meeting, so I hate to go back here, but I'm going to for a second. What's the difference? Like if there's a car accident someplace or construction, anything that constricts the flow of traffic in a city like ours with, some like 2 hospitals, et cetera, and that goes up on one of these boards or on our website, what's the difference between this and that? And I'm going to go there and then shift back to the language and say, if we take a look at provision 8 again and leave the ability to, as you become aware of this change in traffic because of a checkpoint, if we take out, there's some language in there that, we could maybe look at, what's the right word, but why don't we just make it like, if you're aware that there's a, and this could be about anything, if there is a change in the traffic pattern or an obstruction, a checkpoint, whatever it might be, that notification goes out. I mean, don't we already do that? Casey, I mean, I know we talked about this, like, I know I came on late to the meeting, and, I hear what Diane said, like, I hear what Karen said, and then I also hear, Diane, that tension that exists. And so I don't want to put someone in that position, but I don't want to be bullied at the same time. And is it how we're using the language that we need to really consider changing so that we can keep in here? And while we're continuing to talk, I'm going to dig into it a little further, but I know there's some objection in the early days to changing this, but maybe it should just be about, if we become aware of an obstruction due to it, that could impede public safety due to a checkpoint, that residents are notified, and cut it at that. Are you following? Am I making sense? I see serious faces.
Yeah, I think it makes a lot of sense. I think the reason that we went away from that language was because people were trying to get it closer. There was concern that, limiting it to the checkpoints was, kind of straying too far from the original intent. But if really what we're talking about is, is either kind of restricting the language, using some more restrictive language, or cutting it completely because legal counsel can't support, is finding problems. I mean, maybe that makes it more palatable, maybe that makes it a more palatable compromise position. I don't know, but that's, I mean, I think that makes a lot of sense. What else? I know we have to, let's hear from people. And then I know we also have the letter from Kira Kelly that we should, that we can share too. Devin, I see your hand raised.
Yeah, one thing I noticed in Attorney Waugh's opinion is that he mentions at legal discussion point 2, in general, public officials have no greater criminal liability than would private citizens performing the same actions, except in a narrow group of cases, etc. To date, we have had numerous private individuals acting on their own behalf, announcing not just the presence of ICE, but the specific location, and nothing has come of that. Given that this seems to be a pretty common practice, not just here in Lebanon, but in a number of municipalities in a number of states where people that I know live and do the same thing, it sounds like while obviously I absolutely agree that we don't want to put our city officials at unnecessary risk. I don't think this constitutes an exceptionally high risk. I don't think this particularly constitutes more than a theoretical risk at this point. And it sounds like there is at least a general understanding that even if this is something that we could see happening that could possibly come out of this ordinance, that somebody might be criminally prosecuted under something that we haven't been able to locate, that the city's attorney hasn't been able to explicitly locate. It sounds like to do so would be overly cautious and doesn't comport with the facts that we've seen and with the actual practices of people having called out checkpoints and having had no legal action taken against them.
Casey, and then let's go to city manager for the legal memo.
So here's the thing. It is a reality that tomorrow, any one of us could be sued for anything. Nobody could prevent that at all. And it all depends on what is it that they are suing for and do they have a chance of winning. So there is no way that anybody in any capacity could be prevented from bringing a prosecution against them. But we know, I think to a very, very large extent, that the probability of this happening are very low. And if it did, the chances are they will never win. So I think the cautionary part over here, I think we are putting too much weight on it, because it's like, yeah, we could be sued tomorrow. It's like the same way that some crazy prosecution could happen. So I think we're putting too much weight on this probability. Anyway, that's it. We're putting too much weight on it, I think.
All right. Sean, would you be able to share the legal opinion from Kira Kelly?
Yes.
And while you're doing that, can someone answer the question? Amelia Serene put a question in the chat. She said, has there never been a criminal prosecution of a city employee doing their duty, say for something rather mundane? Is that, Bernie, are you aware of anything like that?
I'm not, nothing springs to mind.
Yeah.
What was the question again?
Has there ever been a criminal prosecution of a city employee doing their duty, say for something rather mundane?
I'm afraid I really don't understand the question.
I guess the question, it's like, it's like Barry's example. I mean, what if I don't know, what if a city employee was speeding for, during, what if a city employee, what if a call firefighter was speeding to get to the fire station, because there was an emergency? Does the city, I don't know, do we know of any examples like that?
I don't know any examples, but I think it's generally understood that somebody has the employees have the responsibility to obey the law in the course of doing their duties that they were hired to do, there could be a negligent training if they somehow didn't have the right training, but we assume that they did have the right training. And for example, if they can't speed unless there's I don't know what all the conditions have, flashing lights that the ambulance drivers have, for example, and so forth. But
right.
But the idea that somebody could be charged with a criminal violation and somehow get it okayed by the city or defended by the city because they were doing their official duties, no, I don't know of any examples of that, and that's contrary to practice.
Okay. What about police officers? If a police officer is charged with excessive force or something, I mean, does the city Does the city defend police officers who are charged with a crime?
Not that I know of. I don't, you know, if they in fact are charged with a crime, that's different from, you know, a personnel evaluation. And it's also different from, I mean, we just saw in the paper today that the city of Louisville came to a huge settlement of some kind with somebody who was killed by a police officer. That's a civil settlement.
Mm-hmm.
It has nothing to do with whether the officer is charged with a crime, which is a totally different thing. And the city usually does not get involved in that. And usually, in fact, a criminal investigation is, if it's a city police officer, the criminal investigation is usually done by somebody else.
Okay. Okay.
Karen?
Yeah, go ahead, Casey.
Yeah, in that case also, the first thing to be determined is whether the police officer acted within the guidelines, rules and regulations and policies of the department. If it is determined that the police officer did, the department and the city should defend the officer. But if the officer acted outside of that, then the officer is on his own or her own.
Well, there certainly is a question about, are there conditions under which the city could defend an employee who was accused of breaking a crime while performing their, not just while performing their duties, but the very act of performing their duty was alleged to be a crime. So that's an open question. Let's look at this opinion from Kira Kelly, and I know we're also need to address enforcement tonight. So let's take a look at this. It's good because we're in the public comment section, so we'll kind of consider this kicking off public testimony, and then we'll go to the rest of the public. So anyone else who is here in the public that wishes to add to our discussion, I'll be going to the public after we review Attorney Kelly's opinion here. All right, so she says, I will be concise because Attorney Waugh has done a thorough and commendable job. I don't know, let's just, everyone can read it.
I emailed it to everybody too. You all have an email.
Okay, good. The rule of lenity. Okay. Attorney Waugh, are you also reading this?
I am. I have trouble reading things on the screen, and I also have trouble responding to something that I'm reading for the first time.
Okay. Well, we may not be able to resolve it tonight. All right. So prohibits. Right. So her suggestion is most concerning risk to a city employee when contemplating a highly unlikely criminal prosecution seems to be the lack of insurance coverage for that employee's attorney fees. Risk of a conviction is almost non-existent, and the risk of a prosecution is still incredibly small, but ever slightly more significant. To minimize the risks to city employees, through the passage of this ordinance, the city may wish to explore whether a criminal defense attorney, all right, and this is what Devin had said, might sign an agreement to provide pro bono representation. Attorney Waugh's recommendation. I do believe that this proposed change is unclear and might allow agents to claim that they believe the purpose of immigration authorities' presence is for the apprehension of specific individuals who may not have even committed crimes, only civil offenses, and by claiming this belief, the agent needs not abide by provision 6. And she offers a more narrowly drawn alteration, something like agents of the city who publicize immigration activity in compliance with provision 6 of this ordinance, would be provision 8 though, do so for the purpose of complying with this ordinance and generally increasing public safety. This notification does not indicate any individual's intent to deter the lawful apprehension of criminals. Okay, so that's a suggestion, a possibility there. All right, and thank you to Kathy for sharing Kira's legal opinion here. And thank you for sending that out to us, Sean. All right, how about some more public? Is there anyone else from the public who wishes to weigh in at this time? You're welcome to unmute yourself and announce who you are and offer your comment if you would like. If you want to chat, if you want to type your question in the way Amelia did earlier, that's also fine. And I can read your question out loud if you'd like. I'll just give a minute or two to see if anyone offers any questions or comments. Okay, I'm not seeing any hands raised. I'm not hearing anyone. So let's go back to the group. Barry, I think I saw your hand raised. So I can start off with you. But I think you have to unmute yourself. Uh-oh.
No, I didn't have any comment. Thank you.
Oh, okay. All right. Sorry then. You guys, how do I move my bar? Oh, there, it's gone. Good. Okay. I can't see. All of a sudden Barry's head was totally blocked. So, all right.
I have a face made for radio.
That's not true. That is not true.
Not true at all.
Okay. Who wants to talk? Sue wants to talk.
And I want to talk, but I am, I want respectful of Kathy Beckett wanting to get to implementation as part of tonight's discussion. Maybe Kira Kelly came up with the language that we could really use here, because it talks about public safety. I mean, it touches on all the key points that I think there's concern about, and maybe that becomes the litmus test for the new provision 8. I was looking at what we currently have and thinking about shifting some of the language around, but it doesn't. She might have gotten she way beat me to the punch. So I just want to offer that and do we look to have that tested now and move on to the next, move on to implementation?
I liked Kira's language. I mean,
I really liked, yeah.
I thought that was, I liked it
too. It gets to the public safety thing and says, look, no one's trying to commit a crime here. They're trying to protect, public safety. And I don't want to use, what's the right word to use? And people who are, properly notified, people in the area, nobody's doing it for a bad reason. If you could just bring it up again and read it. So I only saw one. Oh, wait a minute. I can go into my email. Hold on.
I'm trying to go into my email right now.
I was in it earlier. I had a terrible time with my.
All right. She said her language was agents of the city who publicize immigration activity in compliance with provision 8 of this ordinance do so for the purpose of complying with this ordinance and generally increasing public safety. This notification does not indicate any individual's intent to deter the lawful apprehension of criminals. I mean,
law, intent, lawful apprehension, it says if they're a bad guy, get them. But that's not, we're just trying to make sure that the public is properly notified of, of the flow of traffic, of the, what do I want to say? It's been a long day. Yeah, I'll stop there. I think I like her language. I think it covers all the bases. Takes it even a lot further than I was even thinking it could, and that might be the way to go.
Is there anyone on the task force who does not like that language? I see a thumbs up from Diane. That's good. I see, is that a thumbs up from Devin? I couldn't quite see your thumb, but it looks good. A thumbs up from Barry, thumbs up from Casey. All right, Kathy Beckett, what do you say? Thumbs up from Kathy. Okay, we got 7 thumbs up. All right, so let's move on let's move on. All right, so now let's talk about enforcement and implementation. So we had some proposed language in our agenda on this. And Bernie, would you like to introduce this? I think this is something you worked on, or was this Kathy? Was this something you worked on? Who worked on it?
We kind of worked on it together.
Okay, great. Well, then I'll let the two of you talk about it.
Do you want me to? I wrote a few notes just to condense it.
Great. Why don't you go ahead and start, Kathy? Thank you.
So the first provision, sorry, I'm gonna pull it up, has to do with RSA 625.9. This is the only enforcement provision that we had, or statement that was in the original ordinance. And this is so RSA means revised statutes annotated, and they form the codified law of the state. Wait a minute. The state, I can't read it.
State of New Hampshire.
Yeah, subordinate to the New Hampshire state constitution. And this is for classification of crimes. So.
Okay.
This indicates that it's failure to comply would not constitute a crime, but would be a violation offense. Section B designates who can submit a complaint, who receives the complaint, the development of the complaint form, as well as efforts to accommodate language barriers. Section C states the duty of employees to immediately report violations to their supervisors, and the requirement that supervisors ensure compliance. Section D provides that an individual who has a complaint will be given the relevant supervisor's name and a complaint form. The employee who is involved must report the incident to their supervisor. Section E requires that all reports or complaints should be investigated and states the possible consequence of disciplinary action. Section F provides that complaints regarding non-employee agents, including elected officials, will be addressed by the city manager or forwarded to the city council. And Section G states that the ordinance creates no civil liability, but does not preclude complaints in court or other remedies under state or federal law. So one example might be if there was discrimination, that could be perhaps the basis for a complaint based on federal law. That's just my assumption. And Bernie, if I've misconstrued anything, if you could add or correct, that would be great.
Maybe I could just add a few things. The section A is the only part that was actually in the ordinance as passed by the voters.
Right.
The change there was only a minor one. The word offense was was moved from what it isn't to what it is. It's a violation offense that is just more consistent with the as opposed to, it used to say it's not a criminal offense, but it is part of the criminal code. Violations are part of the criminal code, and even though it's not a crime, it's an offense. Sections B through F are vaguely based on the Hanover ordinance. or I should say B through E, although they are somewhat different because of the fact that the Hanover ordinance really only addresses the police department, whereas this really is talking about any employees in any department. Section F is something that I just created from whole cloth because there's a possibility that that violations of the ordinance could arise from somebody who is not an employee, such as a member of a board. And then section G is there are other some model ordinances that talk about should not be construed to create a civil cause of action. How effective that's going to be is a different question.
Right.
And then I thought it would be important to make it clear that that filing a complaint with the city would not be a precondition if somebody thought an issue was of discrimination was important enough to bring a complaint under the state non-discrimination laws. Nothing here is intended to prevent them from doing that.
Okay. All right. Any questions or comments on this this proposal here? Casey?
Can you hear me?
Yes.
Yes. So my only comment and concern is with section B, because who to submit a complaint to. I don't like the fact that he offers multiple channels to the department involved or to the city manager, to the director of human resources. I think we should just narrow that down, let's say to the city manager, or if it is about the city manager, then to the director of human resources. And the reason for that is that in order to establish accountability, one needs to establish responsibility. So if you make multiple people responsible, then accountability becomes vague or unclear. If it is one single point of entry, the city manager, then responsibility is established. Again, unless it is the complaint against the city manager, then it should go to somebody else. But I think giving multiple points of entry muddles the water, and then it prevents accountability.
Madam Chair, could I respond to that just briefly?
Yeah.
I understand the idea that something should be uniform, and I'm not sure what it is, but the idea here, for what it's worth, was similar to the policies that towns and cities have on sexual harassment. There are occasions when reporting to your supervisor is difficult because either they're the harasser or they're in league with the harasser or something like that. And so there is a tendency in those kinds of ordinances to allow for different I mean, there may be somebody who's discriminated against who, for whatever reason, feels that they want to complain to somebody besides the police department or something like that. I mean, I can certainly understand that maybe copies of any complaint should go to some central place, and but that was the reason for the multiple options.
So I'm temporarily chairing here, but can I take the floor for a second and ask a question? Can you guys hear me?
Yes, we can.
Okay.
I hear you.
All right,
Yep.
sorry.
Yes.
So I guess in looking at this, Casey, if I'm hearing you, you're saying if we have too many people, then it just basically, like, it dilutes it. It makes it, if we want to have accountability, we really need to have one point person, correct? Okay, and I think that starting with the city manager's office is the place to go, because right now, when a member of the public has a concern, and especially if they bring it to us, like we run those through the city manager's office. There's a direct policy for, for this. My only thing is that if it involved the city manager, it wouldn't be the director of human resources. It would be the city council that it should relate to, but or should be referred to. I may be taking this too far. I just think it should run through the city manager's office, period. And we say city manager's office because that includes the manager, and the assistant manager, my opinion. So I'm going to bounce that back and see how that takes hold. What do we call this? It's, like a little spaghetti at the fridge. Like, why would we give it to the director of human resources? Except if it was an employee, but if it was a public complaint about an employee, it would start in the city manager's office traditionally, my opinion. I don't think tradition is the right word, technically. Any more feedback on this?
Hi, this is Devin. I just wanted to jump in. Oh.
No, do it. Go ahead.
Did I interrupt someone? Okay.
I know.
I agree with Casey's concern that there really should be a centralized location, that it shouldn't be the sort of thing where if a complaint is lodged with each of the three persons, one individual could have three complaints that aren't reconciled with each other. But I also see and agree with Attorney Wah's suggestion that someone might feel more comfortable talking to a different person, might feel more comfortable bringing the complaint to a supervisor rather than the city manager, or the city manager rather than a supervisor, and therefore wanted to second what he had proposed, that maybe a copy, it be codified that a copy is then sent to the city manager, whether the complaint is lodged with HR or with the department, that regardless of how that happens, there's still a copy with the city manager. I think that sounds like it might be a good way to resolve both these concerns.
So that would be, let me just, Devin, if I'm hearing you, that would be adding another, say, potential person into this chain. So supervisor, do you want to take the city manager out, and that becomes a CC, an awareness where a supervisor is handling the concern?
And Attorney Wah can correct me if I'm wrong, I heard his suggestion or his idea as not adding another person, but saying that regardless of who receives the complaint, the department involved or the city manager, oops, it just disappeared, or director of human resources, that if it's the first or the third, that a copy still go from that person to the city manager. So say HR receives it, they can then send a copy to the city manager. If the city manager receives it, of course, a copy doesn't need to be sent from Sean to Sean, but it would allow all complaints to be kept in one spot while still allowing for individuals to maybe find the person that they feel most comfortable talking to, or the person who at that point seems most acceptable or appropriate to them.
Okay. So Karen, we're just, oops, I lost it again. Oops, you're muted.
Do we still need the document shared? Is it better to have it shared?
I think I'm okay with it without it now, or just
okay.
Let's just hand it over to Diane and then come back. Devin, good.
Yeah, I was just wanting to ask, maybe it's a clarification, and it doesn't need to go into the ordinance itself, but whether the person who receives it administratively, the person who's going to take action with it, needs to be the same person who's receiving it, through whom things are being channeled, because there is that question about dealing with vulnerable populations and how they feel approaching the most powerful people in the system. So, that may be for further discussion, and it ties into a larger question of, at some point we have to publicize this. We're going to have to go into saying to people, you passed this ordinance and here's what's being enacted, and that'll be the time to say to people, if you have a problem, we're going to have a form and you can approach whoever. I wonder, can I just raise a separate question briefly? Because I don't know whether this should go in the ordinance or belong somewhere else, but we talked a lot earlier on in provision 1 about data and data collection. And I'm wondering if we need somewhere to see to it that that we have data about complaints lodged and complaints resolved. That if this thing is going to be real, there needs to be some accountability for how it's treated.
All right, that's a good question. How, Sean, is there a protocol right now for I guess other like violations of, I don't know, like I guess I don't know if police ones are the right one, or are the other an analogy, but are there other, I guess, equivalent, are there other equivalent, I don't know, complaints? It has been a long day. Oh my goodness, I'm barely speaking. Sorry. Sean, do you know what I'm trying to ask you about?
Yes, there's a whole policy that covers complaints investigations. There's a whole policy on anonymous reporting. In fact, there's a whole policy on you handle anonymous reports about the city manager. There's all policies that cover all of this, and that deal with B through all the way down to the end, cover all of that. And so you're asking me to provide you with a copy of those, is what I understand you just said, right, Councilor Hill?
That is,
I knew it. So I can email it out, and you don't need to right this moment, I presume, but I can give you all of those, and I think that'll probably answer all of your questions, and you may not need to do B through the rest of it.
Oh, you think actually that B through F might, or B through G might actually be contained in our other city policies? Yes.
And this will complicate the matter. If you add other variations of it, it'll add immense confusion.
Okay. So there we go. I think that's a good idea. That sounds like good homework for us for the next meeting, is to read what Sean sends us and see if we can save ourselves some words.
I want to send it out while you're talking, and that way you've got both of those policies.
Okay, that's good. Kathy, do you have, we're talking about potentially removing a lot of the hard work that you and Bernie did. Do you have any thoughts about that before we, I mean, we're not doing it yet, but it's on the table. So I guess, do you have any thoughts on this, Kathy?
Well, I guess I'd like to see those policies first before I say anything about that. I mean, yeah.
Okay, fair enough. Yep, that's good. So,
Madam Chair?
Okay. Yes.
I'm just going to say, I think we sent these out with the agenda last week, or not last week, 2 weeks ago, when Sean was on vacation, and I said at that time that I hadn't been able to run these by him at all. So we're now doing that.
Yeah, no, that's good. And we knew we were going to have one more meeting. I mean, we had already kind of, previewed that. So this sounds good. So let us see, what else do we have left that we need to talk about? What about the original purpose statement? Wait, Devin, did we finish definitions? I think we did last week, right? Yes.
Yeah, I think we finished for that and the first 5. It sounded to me like we had finished everything up until an actual vote.
So then I think what about the purpose statement? Did we do anything with the purpose statement yet?
No, we didn't. I do have a question though.
Yeah.
So I've been looking at the question that Sean Mulholland had regarding provision, the original provision 6, section 5, I think it was, or no, original provision 5, section 6.
Okay.
And in looking at that, I also took a look at the original provision 3, because it has to do with communicating information to federal immigration enforcement agents. So provision 3 originally read, no agent or agency shall disclose information regarding citizenship or immigration status. And the section that is of concern is, this section shall not apply when such information sharing is necessary to an ongoing investigation of a felony for which there is probable cause, and the investigation is unrelated to the enforcement of federal civil immigration law. Now, when the exception, so we have provision 4 contain, the new provision 4 contains most of that, except for the section shall not apply when there's investigation of a felony. That was changed to violation of law rather than felony. So I'm wondering if that's something that we need to look into, because that seems to be a change from the intent of the original ordinance.
Okay, I think we need to pull that up. And so that, let me pull that up if I can. That was in our last. Okay. So provision. Okay. Let me see if I've got the right place. And I think it's this one. Okay. Am I sharing the right? Am I at the right place, Kathy?
Yeah, section B.
Where collection, okay. Where collection, retention, utilization, or disclosure of the specific information. Okay. And you're saying that this is different from the original because, just, I'm sorry.
Because the original ordinance, provision 3 said, this section shall not apply when such information sharing is necessary to an ongoing investigation of a felony for which there is probable cause and the investigation is unrelated to the enforcement of federal civil immigration law. So instead, it says violation of law, not related to a felony for which there is probable cause. Investigation of a felony for which there is probable cause. So that's something that I think we should look into. It's not something that we can necessarily address tonight, but I think it's something that we need to, we need to think about. And
can you share a little bit more about your thinking about the
well, I mean,
groups thinking about the language that you had?
Well, it's not the language I had, it's the language from the ordinance.
Right, but the language from the ordinance was what you guys had put together,
yeah,
right?
So it came originally from the ordinance for the welcoming ordinance for the city of Chicago. which is then adopted by the in the welcoming Hartford ordinance, and then we included it in our, pretty much the ordinance that we presented was the Hartford ordinance at the time when it, how it was written at the time that we presented it. There have been some modifications to it in order to, so for example, they said there was one section where legal process was too vague, and so they inserted, according to statute, federal law, court decision. So, but this provision is, is the same provision in those other ordinances. And the reasoning is that we don't want information around citizenship or immigration status to be disclosed to federal agents for something like a traffic violation. Now, when we look at provision, the current provision 5, I said the original provision 5, section 6 is more in keeping with this original provision 3. At least that's, this is something that we need to look at, I believe, because violation is different than a felony, investigation of a felony for which there's probable cause.
Okay. All right. Does anyone have any thoughts about that so far tonight? Okay. All right. So it sounds to me like for the notification provision, which is provision 9, we have consensus about adding Attorney Kelly's language that she proposed, and keeping provision 9 in there. It sounds like we have some work, we have some homework to do to take a look at the policies that the city manager has just sent to us about how the city handles complaints and the chain of command on reporting and those kinds of things regarding the enforcement section. And we may wish to modify the proposed enforcement section based on that. And then it sounds like we have this question that Kathy has raised about provision 5, the new provision 5. Bernie, do you have, I know that you had put together a nice list of things. Is there anything else out there that you had on your list that we have not addressed? Or anything on your, on your list of things that remains unaddressed?
Madam Chair, could I just ask one question before that? What you said about adding the sentence to provision 8, which was provision 6.
Yeah.
Which version of provision? What are you adding it to? There were, in the stuff that was passed out last time, there was one version in italics and one version not in italics.
Okay.
I'm just looking for purposes of my notes here at the moment.
Sure. Yep. So let me go down here. Provision 8. The italics. I believe, and task force members, correct me if I'm wrong, but I believe that we're talking about adding that language to the version that is here in italics. In order to maintain public safety and the orderly processes for all citizens traveling in and through the city of Lebanon, the presence of checkpoints along our roads and highways that interfere with the flow of traffic should be reported to the public if any agent of the city becomes aware of a federal immigration authority's presence at said checkpoint in the city for the purposes of questioning, detaining, or gathering immigration status information from any person or persons or other enforcement action. The city shall act to notify the public as soon as they become aware. This should be done by both the City of Lebanon and community organizations once they become aware. Notification can be made through the Leb Alert system as well as partner organization communications protocols. I think that's what that was the language that we were talking about. You think?
Oh, I'm sorry. I'm just trying to informally keep a record of where you are on things. The only issue on my list that I think you haven't talked about also deals with what was originally Section 5, Paragraph 6, and which is now I don't know what it is now. It's now 7, Section 7, Paragraph 6, and I have the concern I'm raising is different from the one that Kathy just talked about, and that is it the intent of the ordinance to prohibit the city from using the National Crime Information Center? And hopefully it isn't, and if it isn't, then there should be some language in there that says nothing in this ordinance prohibits that. The kind of thing that would be the concern would be, you know, you catch somebody for a traffic violation and the information is put in there, and a federal agency realizes that that's somebody they want for an immigration violation, even though the Lebanon officer hasn't entered any information in on that subject.
So the question is am I looking at the right section right here?
It's Paragraph 6 on what's now Section 7.
All right. I am in Provision 5. Wait, hold on. I am not in the right place. No, I was in the right place. Okay. This must be it.
Right there, 6.
Okay, right down here.
Yeah, it talks about sharing information.
Okay.
And you know, what's unclear is what if you go to a shared database and you enter information that has nothing to do with immigration status, but that information is shared with federal immigration authorities, and you know, it allows them to see where somebody is or something like that. Oh, they must be in Lebanon, they were just arrested. If it is the intent of the ordinance to continue to allow the city police department to use such a shared database like the National Crime, whatever it's called,
NCIC, and also
NCIC.
And CJIS.
Then there should be an exception for that. And if it is the intent not to allow that, then that would be a huge change of procedures.
Okay, that's a question. All right, Casey.
Yeah, I don't think that will be the intent, and if it were, it'll be extremely problematic. Can stress that way. But what I will say is that the chances of that actually happening are nil to none, because the information that is entered into NCIC, NCIC is not of such definite identification that an agent sitting somewhere could say, oh yeah, Casey Montaz is now in Lebanon. Because to make that kind of identification, you will need either DNA or fingerprints, which are not entered in NCIC, except for date of birth, first name, last name, and an address. So I don't think that there will be any action on the part of the federal government just based on the information entered there.
All right, Kathy, I saw your hand, and Diane.
So I've been working on this and Kara's given me some advice as well. So looking at a couple of, well, the fair and impartial policing policy in Norwich and the Hanover ordinance provides some guidance. And I should say too that Lebanon, the new Lebanon fair and impartial policing policy does include some information regarding, when you would access the database is really, that could be something that we could look at that we might want to include, if we could present that information. I'm not sure when you would want that. And then we could take a look at that and see if it's useful.
Yeah, I just want to go to Diane and then we can go to, and then you, Casey. Okay, Diane.
No, I was just backing up what Casey was saying. I think the plain reading of people who were signing the petition would not have gone into that kind of legal examination. But yeah, I do personally, I don't think there was an intent to say, no, you can't use a database. I don't think that was intended at all. So.
All right, Casey.
Yeah, I think it's also important to understand how NCIC works. So the police will enter data there for an inquiry or to enter something that is already, like if they issue a warrant for somebody, they will put that in there. If they want to see if somebody has a warrant, then they will put in the information that they have for that individual. So the police will not be inputting information there accessible to anybody else unless they already have like issue a warrant. Or they have a firearm that was stolen and they're going to put that as stolen with a serial number. Or if they find a firearm, they're going to go and put a serial number and see if it's being reported somewhere. So by just doing an query there, nobody else will sort of see what they are looking for. I don't know if that was clear.
No.
Casey, I think that you're the only one on this task force who knows this. So thank you for sharing.
Let me give you an example. Though. Let's say that I'm a police officer and I stop somebody and I'm going to see if that vehicle is stolen. So I enter the license plate. If the license plate was put anywhere else or stolen, it will come up in the system. If, on the other hand, I have a report of a stolen vehicle, I'm going to enter that stolen vehicle in the system so that if that vehicle gets stopped anywhere else, it will pop up. So that's how it happens. You already have to have established case to input information into it, or otherwise you're just doing a query to see if anybody else has reported that.
Okay.
Councilor Hill, if I could just clarify that, I just want to give an example of how this would work. So say that immigration authorities are interested in the Irish terrorist Sean Mulholland, which is entirely possible that they would be, and they put that in their system, and they put a description of me and they put my date of birth in there, which may be in there nonetheless, and then I get stopped for going through a stop sign. So they stop me and they run my New Hampshire license and it comes back Sean Mulholland, and there's a Soundex response. And federal agencies can do this, and I've had it happen when I was in this business several years ago. So what happens is it comes back as a hit to that agency. Immigration, that Irish terrorist Mulholland that they're looking for, City of Lebanon just stopped him. They're on a traffic stop right now. That's a passive way. The City of Lebanon did not send that information to immigration authorities. However, immigration authorities put a check on that person. So if anybody stops him or issues an inquiry on him, it pops up. And what we're saying is we don't want to be in violation of an ordinance that, because the city didn't actively reach out to immigration, but using that system that advertises that we've just stopped this person. The other way it works as well is immigration authorities, let's say a week afterwards, realize that the Irish terrorist Sean Mulholland is running around somewhere in the United States, and they do a check and see, well, wait a minute, the City of Lebanon Police Department stopped that person several weeks ago. They can do that, and it tells them that. So that's a passive way in which the CGIS and the NCI system works, and we just don't want to make, we want to make sure that it is not your intent to prohibit that passive activity from occurring. I don't think it is, but we need to make the language clear, because otherwise we run back to this issue of, am I committing a violation of the ordinance if I go run an NCIC check? And I don't think that's what you intended.
Okay. Is there anyone, so it sounds like Kathy wants to share some information for us to consider for the next meeting. But okay, I don't know. Is there, do we have to talk about this more tonight? I think this is good for tonight, and we can, and we can put this on the agenda for the next meeting. So for the next meeting, we're going to deal with the enforcement. We're going to deal with this section, and we'll address the purpose and intent, the purpose and intent. We will have, so let's see. Barry, you had done such a nice job, or I guess, are we at the point, Bernie, are we at the point where you need to put together a potential final draft?
No, I don't think so. I just, I made some notes that I sent you about where I thought the commas were supposed to go and the stuff that you did 2 weeks ago. And if Barry wants to do this again, I can just send my notes to him.
Barry, how would you feel about that?
Bernie can send me all the commas that I need.
Okay. That's good. Thank you for doing that. So for the next meeting, we will have a draft a draft that Barry's going to put together. That is maybe a almost final draft that we will complete. I mean, I think the idea, we're supposed to be done by the end of the month. So my hope is that at the next meeting, we can really wrap this up. I think we're very close, and I don't see huge areas of discrepancy between us. So I'm thinking this is actually doable. So if Barry has a version, and then we'll just make our final decisions about the enforcement section and about this section that we just talked about, section 7, and the purpose and intent, then we can just kind of do our workshopping, our final version together as a committee, and hopefully adopt, vote on a recommendation to move this on to the city council. I think that we will want to also plan at the next meeting how we're going to present it to the city council, because I think it would be really nice for the task force to present it. And so that's something, that you can keep in mind too. I mean, I think Sue and I will be at the council table, so to speak, we'll be at the council Zoom, but I think it would be nice for the citizen members of the task force to actually present it. So that's just something for us to keep in mind then. Okay. All right. I think that covers it. Anything else that we need to bring up before we adjourn? Okay. Seeing none. Well then, does someone want to make a motion to adjourn? Sue makes the motion. Let's see, and it's seconded by Barry Schuster. All right. Let's do a roll call. Devin Wilkie.
Devin Wilkie votes yes.
Barry Schuster.
Aye.
Diane Root.
Votes yes.
Sue Prentice.
Votes yes.
Casey Montas.
Vote yes.
Kathy Beckett.
Votes yes.
And Karen Leo Hill votes yes. Thank you, everyone. The end
Thank
is
you,
in
Karen.
Getting close.
Hey. Wait a second. Little change in when we are asking for notification of traffic. Does that happen? That's